Hello everyone, this is the video of Legal Studies, Class 12, Unit 2nd, and the topic is Law of Contract. And under the Law of Contract, today I will be discussing the concept of contingent contract. What is meaning of contingent contract? So, what is meaning of contingent? First, understand the literal meaning of contingent. Then you can yourself appreciate the meaning of contingent contract. Contingent means something depend upon. So it is not an independent, rather depending on certain things. Now come back to contract. Okay, so contingent contract, the contract that is made over some future event. So if that future event will happen, only then this contract will be valid, or else it would be void. So that is depending upon some future event. So that is contingent contract. Okay. Now let's check out its technical meaning. As defined under Section 31 of Indian Contract Act, the contingent contract is a contract to do or not to do something if some event collateral to such contract does or doesn't happen. So I believe now you don't have the problem with such type of language. Now you can appreciate that. That is, under a contract, if you ask someone to perform certain task, that is contract. And if you ask someone not to perform certain task, that is again contract. So both types of act involved in this agreement. Okay, so that is contract. And the contract, as it is said here, if some event collateral to such contract does or doesn't happen, so that is contingent contract. As discussed, it is talking about something future event. For example, all the insurance contract is contingent contract because it depends upon some future event. If that will occur, only then you will get the benefit of that insurance. Contingent contract is also known as conditional contract because it depends upon the condition. So it is simple sentence. Now let's check out the principles of contingent contract. What does it mean? The first principle is the contract which is based on an uncertain future event is not enforced until the time the event takes place. What does it mean? That let's understand this principle with an example. That is, if you made an agreement with your friend B and said that if he goes to meet with C and give this item to him and return back, then you will pay him 1000 rupees. Okay, so this contract depends on the performance of B. If he goes and give that item, only then you are liable to pay the money, or else not. So it is saying same thing. Until that happens, you are not liable to pay the 1000 rupees as you promised. So first he needs to go and deliver that item and return back and collect his money. So that is the first principle. The second one is, if because of any unavoidable factor the happening of the future event has become impossible, the contract becomes void. What does it mean? That, see, you made an agreement with your friend B and asked him to go and deliver that item to C, fine. But in the meantime, B somehow fallen ill and he is unable to go and deliver that item. In this case, well, of course, his health issue is unavoidable and beyond his control. So in this condition, this contract will be void and no one can claim anything in this contract. Okay. The third principle is, if the event has not happened the way contemplated by both the parties, contract becomes void. Let's understand it with an example. You promised Mr. B, if he marries to C through the traditional ways, not through the registry, that is through court. So in that condition, you will pay him 5,000 rupees. But B, though married to C, but he married in the court, that is through court marriage, and not by means of the traditional ceremonies kind of thing. So in that condition, B has no right to claim the amount, because this contract is void, because it is not performed the way it is promised. So this is a void contract. Now the next principle is, if the future event on which a contract is contingent is the way in which a person will act at an unspecified time, the event shall be considered to become impossible when such person does anything which renders it impossible that he should so act within the definite time, or otherwise then under further contingencies as defined under section 34. Well, of course, I believe you must get mesmerized with the kind of language that is written here, but don't worry. Let's understand it with an example that A agrees to pay B a sum of money if, please pay attention, B marries C. But what happens? Before B marries C, C marries with D. Okay? The marriage of B to C must now be considered impossible because she already married with someone else. Okay? So in this case, the contract is void, because normally it is not possible for B to marry with C. Although this is different story, C gives the divorce and if D dies or something like that, but we don't need to go that far. This contract is void because in near future it became impossible to happen. Okay, so that is the meaning of section 34 as we have discussed. Now the next point is, that is defined under section 35. What it says: contingent contracts to do or not to do anything if a specified uncertain event happens within a fixed time become void if at the expiration of the time fixed such event has not happened, or if before the time fixed such event becomes impossible. What does it mean? It is again a lengthy sentence, so let's understand it with an example. A promises to pay B a sum of money if a certain ship returns within a year. Say a ship went to US from India, and in the meantime A promised B that if that ship will return back again India within a year, then he will pay certain amount. The contract may be enforced if the ship returns within the year, and becomes void if the ship is burnt within the year. So because of any reason, if ship doesn't return back in the year, maybe it sank, maybe it is burnt, maybe because of some legal reason it is trapped in the United States itself. So because of any reason, if ship couldn't return back in that year, then it is void, or else if it returns back within the year, then it is valid contract. Okay, that is the provision given under the section 35. The last principle of this contingent contract is contingent agreements to do or not to do anything if an impossible event happens are void whether the impossibility of the event is known or not to the parties to the agreement at the time when it is made. That is defined under section 36. So this is another interesting point. Let's understand it with an example. If A agrees to pay 1000 rupees to B in a condition when B will marry C's daughter E, but the time when this contract was made, even before that, C's daughter E already died. So in this condition, how this contract will be valid? Because the condition that is given there, that is already impossible to perform, as C's daughter is already died. So that is not a valid contract. So these are some of the important principles of the contract, or basically contingent contract. I believe you must understood. Now I have another term that is related to contingent contract, but not exactly contingent contract, rather it is known as waiver. So as section 30 of Indian Contract Act states that agreements by way of waiver are void and no suit shall be brought for recovering anything alleged to be won on any waiver or entrusted to any person to abide the result of any game or other uncertain event on which any waiver is made. Well, waiver is nothing. You don't get again mesmerized with the kind of sentence it is given here. The point that you need to understand through the meaning of waiver is, if you bet something. So let's understand it with an example. Suppose the cricket match between India and England is going on, and your friend and you both bet, if India will win, you will pay 1000 rupees, and your friend said if England will win, he will pay you 1000 rupees. Okay, so this is bet, and that is not allowed legally. As remember, we have the concept of lawful object, that is one of the principles of the valid contract. So this is not a lawful object, so this agreement is not valid. So this contract is also not valid, it is not enforceable. So waiver is an illegal act, keep in mind. Okay, now but the point is, waiver and contingent contract, why both terms are kept under the same topic, that is, waiver is also depend on the future event. It is talking something which will happen in the future. Okay, however, let's understand what is basic difference between contingent contract and waiver. Based on the legality, you can see this table that will help you to understand. Okay, so based on legality, contingent contract is valid and legal. On the other hand, wavering contract, that is void and illegal. Based on object, it is lawful, and wavering contract, that is unlawful. Nature of promise, not essentially reciprocal. Okay, what does it mean that? First let's understand the meaning of wavering contract under this heading. Essentially reciprocal. Okay, because both of you promised something while betting. If you win, you will pay. If you lose, you will get the money, or vice versa, whatever. That is not much important. But the point is that you need to focus on, in any condition, either you are receiving something or giving something. That is reciprocal. But in contingent contract, it is not essentially. If you promise to give something, from other sides no promise at all, that is fine. Okay, so you are not receiving something, maybe or may not be, but here either you will be at loss or at benefit. Okay, so this is the another difference. And the last difference, that is occurrence of future event. Future uncertain event is merely collateral to the performance of the contract. Okay, so what does it mean? That whatever the promise that is made based on the future event, that is merely a collateral to the performance of the contract. If that doesn't happen, it is void. On the other hand, the fulfillment of the contract is determined by solely happening of the future event. So it is exclusively depending upon the event, that is, as we took the example of cricket match, either win or loss. So that has to be there. Okay, so solely happening of the future event. So these are a few differences between wager and contingent contract. I hope you must understood the meaning of contingent contract and wager and differences as well. However, again I repeat, watch it again to understand this concept, and see you in next video.